For the last concluding session, the way we have two excellent speakers who have so far have not been silent, but have not had a chance to properly present and be presented. So I'll immediately present the two of them. And yeah, you want to? Okay. So and then the idea is we will not have two 20-minute lectures. This is much too much at this late at the game. But we will have a brief conversation around some of the themes that we have, Yael and I have picked out of the proceedings of the last 2 days. And we will offer the speakers an opportunity if they wish to comment on those themes, but they get the right of first refusal in the sense that if they are not interested in, so it's like a pass. Which game is this when you can say pass? So they can pass on the opportunity, and then of course we will open it also to other members of the audience who would we invite to make a short intervention. Okay, so because we have to, at 7 o'clock the carriage becomes a pumpkin, so we have to by that time to finish our proceedings.
And some of us turn into frogs.
Yeah. Right. Now that I'll wait to see. So our very dear friend Noam Lubel is a professor of law at the University of Essex. He was the head of the school at Essex. He's a director at the Essex Armed Conflict and Crisis Hub. Before that, he was in Galway, a lecturer, and before that, many years ago, he was here at Hebrew University as a postdoc. And also has a PhD. He also has degrees from this university. You have a BA from this university,
philosophy,
right?
Yeah.
In philosophy. And Noam will also come back to teach this year at Hebrew University, so he's also part of our adjunct faculty and also is involved in some other projects. And Noam was here at the very first conference in the series, which was for Noam a very meaningful event because there he met his future wife at that first conference. So it's not only about IHL, it's also about matrimonial life.
And all the organizers of that first conference are claiming responsibility for introducing us at very reasons. Yes. Yeah.
For the shidduch. The other speaker on this panel is Gleb Bogush, who is, unlike Noam, this is the first time he's here and in Israel, and we are very happy to have him with us. Gleb is currently with iCourts in Copenhagen. But before that, he was an associate professor of public international law at the HSE University in Moscow. He has a law degree from Moscow State University. And he was also a Humboldt Fellow at the Max Planck Institute for Foreign and International Criminal Law in Germany. Yael Ronen, you all know, who's my co-moderator.
Apparently I need no introduction, but I was introduced yesterday, so yeah.
Yael needs no introduction.
That's what they said.
So here, Yael.
Okay,
run
no.
the show.
Oh, okay. Okay, so I'll leave my thoughts to the end if there's time. I was just going to say, want to add one thing to what Yuval said was that we open the floor to interventions, and that would be actually the time where you are allowed to make more of a comment than a question. But we will start with Noam and Gleb, and I think that what we suggested was to discuss a few overarching issues or important issues that arise from the discussions, and we broke them down into smaller questions in case somebody needs help in navigating their way. And I think that the issue that is like the big issue of that we started out with yesterday, and we could see it playing through various topics, was the issue of separation between use ad bellum and use in bello, or rather the erosion of the separation. Is there an erosion? What are the consequences? Is the Ukraine conflict the one in which, and this is the one that I personally find myself questioning, is the Ukraine conflict the one where we need to establish our new expectations and standards, given that it is such a classic this is a war, and the classic war that we all study, that this is how wars work. We know who the good guys are, we know who the bad guys are. and it's easy to devise rules based on something like a situation like that. But then what happens when we'll have other wars or other conflicts that are not so, the party, it's not so clear cut who's good, who's evil, and how the rules should work. But we'll be trying to apply rules from classic cases. And when I said that, Noam said, oh yes, I have something that I want to say about that. Not specifically about my concern, but about jus ad bellum, jus in bello. So Noam, yeah.
I have something I want to say because you said you'd be asking this question, so I thought of something. Thank you for the organizers and especially Anat for many times helping out with everything when I've been here. And actually, Yuval, you mentioned I was here in the very first one, and not only was I here in the first one, I was on the closing panel of the first one. So it really is. Yeah, exactly. It was stuck in the same place for 17 years. No, I think I had a few regular sessions in between, and some of them. The separation. I think, Jeff, I think you mentioned in your presentation, you mentioned the saying about hard facts or bad facts, right? Making bad law. I think in this case, it's the problem is almost the other way around. Easy facts could make bad law, and I think that's what we need to be really beware of. I mean, because if we take this case and we start sort of linking the ad bellum and in bello a little more on the basis of this easy facts case, what do we do everywhere else? Because in most cases we don't have. I mean, think how many times in recent decades have we had such a clear-cut case? And then if we say, okay, well, maybe we don't need such clear-cut cases. Maybe there are other ways to know who the good guys and who the bad guys are. Maybe we could use, say, ICJ pronouncements or something like that. Well, that's not going to really help. Although it's interesting, just thinking of the recent news with the new call for an advisory opinion. What happens when that comes out? What happens when the ICJ says that the occupation is unlawful, and we have now linked questions of ad bellum and in bello? From that moment, does it mean that everything Israel is doing on the basis of the laws of occupation is unlawful? Right? At that moment, suddenly, no more law and order from the IDF. Every detainee that's held under the laws of occupation will need to be released. I mean, that's a similar type of scenario. If we start linking the two, now you could welcome this outcome, maybe depending on your views. You could reject it. But it would be something that we'd need to consider. But even that would be a really rare occurrence of an ICJ pronouncement of something that's still ongoing. Because in most cases, again, as we know, we only get the pronouncements years after. So we're not going to get consensus in most cases. We're not going to get rulings in most cases. And so I don't see how we can use this case to suddenly change the way we've been looking at it. I know there've been lots of, there's been renewed interest in various, just war revisionist theories that try and argue for it. Look, these are really interesting. You mentioned earlier, right? I have a degree in philosophy. From a philosophical perspective, it's fascinating. I love these debates. Right? But I have never heard a revisionist theory or a person, when I've debated with them, provide a convincing explanation of how this works in practice. It just doesn't.
Lev, do you want to comment as well?
Thank you very much again for invitation. This was a really fascinating conference. I also would like to thank all participants, because there was 2 days of not only listening to your presentation, but also extensive exchange. And this was really, really great days in terms of our, so that's I agree that it's not this were probably not a game changer, as Maria Baraki put it yesterday, but I still think that it's an important moment to realize, to have a sense, not maybe of erosion of the distinction, the separation, but the understanding of the link, because mostly these days we talked most of the time about violations, the different violations of the principles and rules of international humanitarian law, and in this conflict, it is obvious how they are connected to the use of force, which was manifestly illegal. And I think this manifest illegality kind of opened the door to the violations of international humanitarian law, and it also opens the doors to the erosion of this distinction between jus ad bellum, because the impunity for the previous violations, and of course the feeling that it is manifestly illegal, doesn't subject to any international control, international scrutiny, of course, allowed all these things which are now happening in Ukraine. So I have a feeling that it's important to tackle this moment when we fully understand the importance of the prohibition. And I think we need an honest debate about this war, because many times we hear during this conference that it is already almost 9 years, and in terms of jus ad bellum, I don't have feeling that there is a huge difference between what happened in 2014 and what happened in this February. In a few days, the Dutch court, the district court of The Hague, will render judgment on the case of MH17. You know, all this tragic story. In my perspective of the conflict, it's emblematic crime. There was the crime that is framed by Dutch prosecutors as the crimes under domestic law, the murder. And this is never have been actually framed seriously in terms of international humanitarian law perspective. So probably the prevailing theory that it was a mistake, the unintentional attack on of the military aircraft, Ukrainian aircraft, and was resulted in the attack on the civilian airliner. I think it's important to understand this in the context of this conflict. I think it's one of the crimes that have been attributed to aggression. And now we have. We discussed a lot of victimhood, the immense victimhood of Ukrainians, and even the environment and animals. And I think the most of this damage cannot be attributed to IHL violations. It's the victims and the damage that has to be addressed. And I think the most important lesson that we have to learn from this debate is the relevance of jus ad bellum, and that we have to keep separation. I agree fully, but we have to also understand better the relevance and significance of this moment to address fully the war of aggression.
Thank you, Gleb. I mean, if anyone wants to interject, we can take 1 or 2 comments each round. I will just say that one aspect that I think we covered but may have not covered in full is the duties of third parties given vis-a-vis the conflict, given that this is a war of aggression. We talked a little bit about neutrality and maybe the end of neutrality. I think the position of the Swiss government, I think, was emblematic of erosion of the status of neutrality in the face of a war of aggression. I think the fact that we did not have an ICJ, but we did have a General Assembly resolution that was passed by a very large majority may have played a role in this part, and that also goes to Noam's point about the importance of international bodies in identifying aggressors and victims in situations. We haven't discussed really the Security Council and its role and probably its failure to meet its obligations to maintain peace and security. But that
I wonder why.
Why we have not discussed this, or why has it failed?
has difficulty with this conflict, yes.
Yeah, I still think that for us lawyers who are following this, the fact that there is, it's a question whether we should simply acquiesce that we have a broken political system at the international level, or whether we should try to think, okay, so what is our plan B or plan C or plan D or plan ICC? You wanted to comment, Roger. Roger and Jeff, and then we'll go to the next round. And in the end, hopefully, we'll allow miscellaneous comments on everything.
Well, I already had a longer comment today, so this is more of a question than a comment. From Noam, I got that he seemed maybe a bit more hopeful than, at least when it came to ad bellum and Gleb's comment. But I was wondering that, to what extent the panelists, you think that with this war where if as IHL lawyers, you basically see every single relevant provision coming up in some way, and also almost every single provision being violated, and how law always runs behind the facts. And you have, like, after the big conflicts, we get new, we have in the past at least gotten new rules, but we already know, and the IC identified this, that there's an unwillingness for states to adopt new rules. That's why we have all the expert processes for everything. To what extent do you think that we, and then we, I mean like IHL and we people busy with dealing with IHL, can get out of this better? That actually there might be something that the Americans often refer to as a Groucho moment. I always find that a bit of cultural appropriation if they talk about that. But as a Dutch person. But whether IHL could potentially come out of this better, or whether it's the other way, that this will be kind of the example, like, all right, so long as you're a P5 or this is it, kind of.
Right. No answers at this point. Jeff.
Yeah, just one endorsement of I actually think that this conflict reinforces the importance of the distinction between ad bellum and in bello. And one aspect of this, I think, that is often overlooked in the discussion is that the in bello, the beneficiaries of the in bello are not just the civilians or the wounded and sick, or it's also the combatants themselves, the participants in hostilities, because they have to live with what they do for a long time. And defective leaders, derelict leaders, they don't understand that. They allow a level of brutality, and you can justify it by saying that the enemy is unjust or you're just, whatever the case may be. But in the end, it's young men and women who have to do the dirty work, and they have to live with it. And the law has historically not only preserved order, good order and discipline, but it's also helped young men and women deal with the moral abyss that they're thrown into. And I think we have to be very careful about, senior political leaders saying you don't have to worry about that anymore, because they're not the ones who are actually doing the brutal business of unjustified violence. One other topic I think that is really significant from this conflict that didn't come up was whether the combatant qualification requirements of the Third Convention have been kind of laid bare, that you have to distinguish yourself at all times when you're dealing with areas that are under enemy occupation and you're a resistance fighter. And I actually, I was brought up in the American military legal culture where that was like gospel, that you had to reject the Protocol 1 dilution of combatant status. But I think the conflict in Ukraine has actually shown some of the wisdom of the showing your arms openly, immediately preceding attack, the unrealistic expectation that you're a resistance fighter in occupied territory and you're going to walk around wearing a uniform all the time. It just isn't going to happen. And how that plays out in terms of allocating status, I think, is an important area of inquiry from this conflict as well.
Thank you. The second topic we wanted to put on the table was the question of parties to the conflict, which I think is something which came out quite vividly yesterday. when we had a discussion about which states are parties to the conflict, what to do with individuals and groups that are involved in the fighting, how should we conceptualize the aid and assistance that is provided to the parties. We focused a lot on the Ukrainian side, but of course you could also speak about provision of drones by Iran to Russia as another perhaps set of factors. We also even raised, I think even I raised the issue of a private company and its involvement. And the question to you, Gleb and Noam, if you want to care to address it, whether we have seen in this conflict whether this conflict is perhaps a harbinger of a more diversified combat field, even in what appears to be like the most classic interstate war that we have seen in Europe since World War II. And even that is, we are seeing it's quite hard to characterize or to define. So what would you think of that aspect? Gleb, you want to? No.
So we had a good session yesterday, I think, which no need to repeat some of the discussions around becoming a party to a conflict and all of those. I think lots of good points were made there. I think to a certain extent the concept of neutrality and its relevance or irrelevance has perhaps been brought out to bear in this conflict, because even with all the discussions of neutrality or ideas of qualified neutrality and so on, we still end up coming back to sort of the ad bellum side of things rather than neutrality, and to questions of sort of IHL in terms of party to conflict rather than laws of neutrality. I think in terms of, you mentioned the Iranian drones and so on, so I think maybe there's not been enough discussion of state responsibility in terms of assisting an unlawful act. And that's something that needs to be looked at with those states that are assisting the Russian side. But that's not so much an issue for the states that are assisting Ukraine. I think generally with becoming party to a conflict or not, and this is something we've seen also with the Syrian war, for me, it's and this is one of the toughest things when I'm teaching, and we look about sort of classification, parties to conflict. And if you apply the law the way we've usually looked at it, really everyone is at war with everyone. Right, we can make pretty good arguments, and already without the Ukraine. Well, so going back to Syria, we can make good arguments that the US has already been at war with Russia, that Israel's at war with Iran right now already. I mean, you can make arguments for pretty much everyone being at war with everyone, and yet, you know, politically, nobody wants to say that. And the danger, in a sense, that applying the law diligently could lead to an escalation of conflict, is one that I think we need to be aware of. And again, it's the Syrian conflict and it's this one. And perhaps it highlights a dissonance between the law and the politics that needs a bit more thought, because maybe then the law isn't quite working if it keeps leading to a result that we don't want to acknowledge. The other point in terms of parties to the conflict relates to individual involvement. And again, here with regard to whether it's, you know, groups and armed groups, I think the law is relatively clear. I don't think it's that complicated. It's more the individuals and the way individuals have taken part without necessarily, so people that haven't sort of formally joined a territorial army, defense force or anything like that, and whether it's using, you know, there was this app that's used to identify incoming missiles and aircraft and so on. And there's an argument to be made these people are directly participating in hostilities while using that app, for example. And it's you know, so that's a dangerous notion, a dangerous thought, a risky one. But when you're talking about people feeling that they're defending their homes, and then, you know, this also comes back to concepts of levy en masse that in theory we thought, oh, that covers it, but it doesn't actually work here, because that's only for the very opening moments, and it doesn't really apply to most of what we've been seeing of people in the streets taking up arms. And so I think we have seen a situation where, at least again, applying the law strictly, huge numbers of civilians that we wouldn't like to think of as being involved in the conflict have been participating, and there are a lot of risks and dangers there. And for me, that's another thing that we do need to be considering, both in terms of how we interpret the law, what it's meant to do, and are we doing it correctly.
Yeah, I fully agree, and this is, I think, the point where the wisdom of states, which we normally criticize, just the states are right to be careful, to be very careful, because it's really, we have to understand the danger of this strict allegiance to the rules. So I agree.
Before we take any questions or comments, I just have a question for Noam. You say that if we expand the identification of states as parties to the conflict, that might actually cause an escalation. And I'm just wondering, given that that the law has not inhibited action so far, is it an obstacle now? I mean, would Russia attack the U.S. if it considers if the U.S. considers itself to be a party to the conflict, or Russia considers it, based on that characterization, or would it attack it if it decided to attack it? And if it's not attacking it, it's not because it's not a party to the conflict.
Or would Iran provide the drones if it knows that it will open itself to?
So let me put it back to you. What happened if the lawyers' pronouncements became formal and public, and tomorrow morning in the headlines of the papers, it's whether it's in the US or Russia, it's US and Russia are at war. Right? Do you not think there's a chance that could potentially lead to escalation? And the same if it was the Israeli papers and the Iranian papers, and this is the problem. And this is why, even within the US, there's sometimes been sometimes they've been saying, oh, the lawyers are stopping us from helping Ukraine anymore. We want to help more, but the lawyers have told us we shouldn't. It's not that the lawyers have said we shouldn't. The lawyers have said, listen, you're treading a really fine line right now already as to whether you become a party to the conflict or not. And if you do any more than this, you definitely do. And it's the fear of the escalation, I think.
So these are going to be two brief comments, not really questions. The first one is, and it's clearly colored by where I'm coming from, there is a huge inclination to apply or interpret norms in this case as it fits, because we clearly have a party, the global West wants to align with. And I think there is a huge risk of creating very dangerous precedents and establishing rules which will not necessarily be conducive to international legal order in the long term. And that's a tendency I've seen in many places, less here, but especially in many European forums, there is a huge inclination to do that. The second one is, and this is purely on methodology, I think we'll have to, in the future, look closely for opinio juris when it comes to acts, what was done and what wasn't done for political reasons, and what was done or wasn't done for legal reasons. And when it comes to what you just mentioned, whether or not Russia would attack the US or, broadly speaking, NATO, I don't think that's always colored by the conviction that this is not allowed by law. This is often political. So in the long run, I think it's important for the methodology of public, international, or globally to bear this in mind. That's about it. Thank you.
Yeah, so I've said too much on party status probably already, so I'll just say something on neutrality. So Noam, I fully agree with you that this conflict once again lays bare all the deficiencies of that old body of law. But it's not the first conflict that does so, doesn't it? And so we can wonder why, at least up until that conflict, states have always been so, reluctant to give up on that old body of rules. Just it seemed to be convenient to have it there underneath that UN structure that we were building upon it, and from time to time then pulling it up when handy, pulling up sometimes even just ideas, structures from the law of neutrality, and transforming them into concepts of due diligence, whatever. So I think it's quite a fascinating thing to be thinking about. And I just anecdotally remember that in 2021, Italy, in its position paper on cyberspace referred to the law of neutrality quite extensively. So, even in that domain where we might think creatively of rules and regulation, even there we come back to that old regime. So I'm not so sure that states are in the end with this conflict and after all entirely giving up on it. But I'm very curious to see how it will play out.
So a third issue that we wanted to raise was the appearance of different types of conduct. That the question is whether they fall within participation in a conflict. So Noam mentioned the use of an app when it comes to individuals directly participating in hostilities, but we also have states with information sharing and intelligence sharing. Or cyber operations more broadly. And I would add to this alongside the idea of new type of conduct. Would that fall within conduct of hostilities under IHL? What about types of protected lives or protected values? For example, we talked about the environment. We talked about non-human animals. Should IHL be expanded to include those? And how do they fit into the framework? So, Gleb, you want to start?
Yes, I believe it was a very important point in our conference. So when we address this problem of the expansion of international humanitarian law, and I fully agree. I think this four, especially the recent events concerning not only power plants but the other objects and the impact on environment, which we really don't appreciate right now. We don't appreciate right now because it's. I think it's very dangerous to be neglected, and I think it should be addressed. And I also think not only about the. I think environmentalization of international humanitarian law, but also about the link between jus ad bellum and environment as well. So this, I think, it's important point to connect all these areas of law. I think it's also important in this conflict.
So I think this a lot of the discussions around environment also. And sort of new areas and new protections need to be put in the context also of the need to, at the same time, not take our eye off the ball with the most basic fundamental rules. And what's been interesting about this conflict in many ways is also the extent to which what we have considered to be the most basic rules have been violated right and left. But I think something that links perhaps both some of the sort of environmental long-term harm together with the basic rules is and again, we talk about Ukraine, but a lot of this was in the Syrian conflict. If we're talking about recent conflicts, is the amount of urban warfare and fighting that's been happening in cities, and I think it's been highlighting issues that have been under discussion for a long time. The basic premise of IHL, the most fundamental, really in many ways the one that underlies almost everything else, is distinction, right? And this expectation that the attacker distinguishes and that the defender does everything possible to separate between the two. And what's been happening here, and I mentioned this in my comment to Marco yesterday, is it gets difficult when it appears that at least for one side there's no choice but to be operating from within an urban area if they're defending it, and there's this vicious cycle that happens because once the Ukrainian side has its armed forces inside the cities trying to defend them, these same armed forces are themselves legitimate targets, and then they can be targeted with the proportionality rule that comes with it, and suddenly the civilians around them end up suffering, and this suddenly comes all within the IHL framework. But also, and just sort of again looking at how, and a few people have mentioned how we might suddenly view existing and past conflicts differently because of this one. In the past we've been very quick and think about this region here to criticize armed groups for fighting from within cities. Right? It's interesting to see the reaction now when it's a state that's fighting from within a city and from its own perception acting in self-defense. Well, these armed groups from their own perception are acting in self-defense, and if you don't have the pronouncements on the the ad bellum sides and so on, I'm curious to see, say, next time there's a serious round of fighting involving Gaza, will observers be more accepting of Hamas operating from inside urban areas than they have in the past, looking at what's happening in Ukraine, or not? I'm curious. I'm just saying that we are drawing conclusions now from this conflict that might be applied differently suddenly, when you come back to old or renewed conflicts. But a lot of the problem of operating in urban environments is also the level of harm that's done to infrastructure and to the environment, and long-term harms. And it raises the questions of how do we take into account long-term harm, reverberating effects, and so on. And again, these are problems that we've seen for years in IHL, and I think we're trying to shoehorn a lot of this into the proportionality rule, including protection of the environment, and I don't think it necessarily works, given that the proportionality rule of IHL is meant to apply to commanders for specific individual attacks, and I just don't think they have the information or the ability to make these calculations, and so there is a problem. I won't get into this now, but there was the article, if anyone's interested, that I co-authored with Amichai Cohen a couple of years ago that we called Strategic Proportionality, and we were looking exactly at this problem of the things that don't quite fit in terms of the effects, but also on the side of the state. In the in bello rules, and a lot of that is precisely long-term harm that can't be attributed to single attacks, but is sometimes the most devastating harm of all.
Yeah, if I may add just one comment before opening it up to a quick round of reactions, I would agree with Noam's point about the sense that we are superimposing a lot of other values and norms on the rules of IHL. I mean, we talked in this conference quite a lot about human rights law as, the general comment, which I personally like very much, but it was mentioned quite a lot. We also talked about environmental law. We talked, animal law. I'm now moving to a very different area. We talked about gender-based violence, and which are notions that emanate not only from IHL but also from instruments that were created to protect the rights of victims in a non-warlike context. We talked this morning about digital misinformation, disinformation, and content regulation. So it seems as if we are in a process of significant complexification of IHL and introduction, an attempt to introduce some systemic integration, interpretive methodologies or complementary applications into IHL, which certainly from the vantage point of which Jeff emphasized a few times of the soldier or the commander on the field, it makes it extremely challenging to comply with all the regulatory frameworks in real time. So maybe we do need the robots to kick in eventually. Shani?
Thank you very much. I have a question or wonders. Yael raised the question of expansion of rules, which also raised in our panel, and there's the law versus the practice, and Noam raised now the indication of maybe an undesirable results. So I'm wondering, mostly as an IR student, what is the role of lawyers in the context of international law, and why do we insist on strict legal analysis when the result may not be what we want, and maybe it's detached from reality? So maybe we should also think about what is our role as lawyers and legal scholars. Thank you.
Yes, Anna?
Of course. Thank you. I will follow Alexander's example with talking about the law of neutrality, and not my topic, but I'm afraid I will relate it to my topic eventually. I think it's quite interesting when we talk about NIAC, for instance. There we still have the law of neutrality, which also relates to the environment and international environmental law and third parties that based on the law of neutrality have an environmental implication. And fun fact, Article 35 is about the basic rules. And the ecocentric rule on the environment is included in Article 35. So it is one of the basic rules, interestingly, even though it's not seen as such a basic rule. So thank you.
Thank you, Anne. The penultimate topic that we want to raise is the issue of compliance, because I think this has been, of course, and Gleb alluded to that, that has been a very stark, I mean, what we have seen in Ukraine has been a terrible failure. I mean, if IHL is intended to introduce, to humanize warfare, we have seen inhumanity on a very large scale, and we are still seeing inhumane action and probably crimes against humanity perpetrated on a very large scale. And the question is really for us as to whether we, again, as lawyers who are, or IR students and professors who are working on these issues, do we see any silver lining, any direction in which we can think about strengthening compliance? Of course, we all have to be mindful of the very particular configuration of this war, which has a superpower, which has a permanent seat at the Security Council, and from that perspective, of course, we haven't discussed very much the Iraq War, but the analogies have been made also to the Iraq War and the failure of international law. I don't want to enter into, legal comparisons as to grounds, but I will note that this may belong to a category of conflicts involving superpowers. If China is enmeshed in a conflict, we will see probably the same failures. And the question to you is whether you see any road out, and whether you think international criminal law, perhaps an aggression, a more robust attempt to enforce the crime of aggression could be part of the solution.
Okay, so I try to be very brief, and the last point that you made about the criminal law, international criminal law, I think we all understand the limits of criminal prosecution, especially with regard to this superpowers and the all circumstances of this conflict. But it's still relevant to address these crimes. I think it's not only important to name and shame particular persons, but to make a point about these priorities and the significance of these violations. It's also important for prevention in a global scale, also for the future situations. With regard to the idea of aggression, I think we all know that it's a lot of skepticism, a lot of critical points. Most of them are political, not legal, and I understand them, but I do support the idea. I think that's very important to make crime of aggression relevant, because it's characterized as this conflict. It's exactly what happened. It's a major thing, and if we overlook for various legal reasons, jurisdiction is limited, we have immunity problem, I think it's important to address that. And I think there are ways. We have to be, as they say, Maria Varaki, my good friend, I said for the second time I addressed her intervention, we have to be more flexible, more creative. We should not think about the same magic, personal immunity issues. We don't know what will be in 5 years, and whose immunity we will discuss at that time. I think what is important is to address the criminality of this war. This is what ICC is seeking to do in its policy documents, but ICC is not competent in aggression in regard to Ukraine, and I think it's a good idea. It's not something that is not possible, but we have to be particularly. I think we have to be flexible in that. What one topic that was touched upon today is the issue of disinformation. I also would like to point that there was also the importance of propaganda. It's not the first time, of course, that we had this problem, but in this war, propaganda played a key role. It was probably one of the main culprits, main perpetrators of this war. And this is also a chance to address it. We have international basis for that, Covenant of Civil and Political Rights, International Covenant of Civil and Political Rights, and we have the criminal law of all countries that involved in the conflict. The Ukraine, Russia, and Belarus, they all criminalize the propaganda of war as international crime. So I think it's also an option for the tribunal when we design and when they discuss this issue. So I do support this idea. But again, we have to discuss this option, criminal prosecution, together with other things, and in particular reparation discussion. We had a lot. We had this talk, but I think it deserves more attention. How to address reparations, how to address the victims' rights, and how we accommodate victims and their rights to reparation within the accountability. Thank you.
Yeah, just to say that I'm actually relatively confident that we have started seeing and we'll see a range of accountability actions taking place, whether it's in international criminal forums, whether it's ICJ, we spoke about sanctions already earlier today, whether it's some kind of a claims commissions, whether it's some kind of bespoke mechanism tribunal. The bottom line, I think, is where there's a will, there's a way. I think there is a will. I know Yuval mentioned Russia being a superpower, but actually I think other than the veto that they have on the Security Council, part of what's been happening, I think, is actually Russia's being exposed as less of a superpower than maybe we thought. China's a different story. Hopefully we don't see a big conflict like this with China in the near future. But I think with regard to Russia, where there's a will, there's a way, and I think there is a will.
Okay, so we'll move on to the last topic, and we'll open that for everybody. It's something that Ohia actually alluded to earlier, and that is the question of IHL, quo vadis IHL, like what something a little more general about that. And earlier, Ina said something about IHL being a natural kind of law, and good people don't commit war crimes. And it's from the humanitarian section that I heard people going, So one of the questions that we wanted to raise was whether IHL can still claim to be grounded in moral principles. And how is IHL coming out? How is IHL coming out of this war? Like Ohil said, does it need to be modernized? Can it be modernized? We're probably not going to have another peace conference with new rules, but you said we need to be more creative about international criminal law. Maybe we need to be more creative about IHL. So this is everybody's opportunity about this and everything else. Yes, Manu.
I was one of the people pulling a face, but the face I was pulling was not that somehow there's shortcomings in IHL. What prompted me to pull the face was the comment that good people don't violate IHL, which unfortunately I don't think is an accurate reflection of reality. So just to justify the face. Sorry, I'm going to come in. I missed the moment at which to react to the silver lining point earlier. And I feel that obviously beyond what's actually happening in Ukraine, there is a silver lining. In the first couple of weeks, I was going, what happens to the rule-based system? Is everyone going to say the violation on the prohibition on the use of force is rendered irrelevant? And it was actually really heartening to see just how extensive the support was from every quarter to the letter of the law. And I think the acceptance of the political reality. So I would say to the extent that there is a silver lining in this, it's a reaffirmation of the importance and the belief in these prohibitions, even though in this particular case. When it comes to reparations, you miss me like the Italian. I don't need the mic. That's always going to be when there's a will, there's a way.
Okay. Noam, you wanted to also remark, and then Anna, and then we conclude. Anna and Saba, and we conclude. I have to be very brief because I made a promise and I have to keep my promises.
So just to say, first of all, in terms of sort of IHL and does it need modernizing and is it working? I think one of the interesting things to see is actually, and it goes back to the question also of the one-sidedness of what's going on. Ukraine, by and large, seems to roughly be operating in line with IHL. Right. I mean, there's always violations in every conflict on all sides, but generally speaking, Ukraine is adopting an approach of following international law in this conflict, and it is having some success in the conflict, and it is having support of the international community in this conflict. And I think that's a pretty good advertisement for, yes, you should be following international law because you can actually, get somewhere by being the side that follows the law. So that's one argument here, but in terms of the moral side of it, I never thought that IHL is meant to be, every single rule is meant to be, tacked onto a particular moral, ethical framework. That's too complicated. It won't work. The bottom line is that, it's a framework that acknowledges that the world's a shitty place, wars take place, states will go to war, armed groups will go to war. We're not going to be able to stop that. Let's try and come up with some kind of framework that allows them to do something, but also injects humanity into it. And as long as we have this framework, this is the one that we've got. As long as it reduces some of the suffering of war, and we see that it does, then it's got a moral basis. I don't think that this war's changed that idea. That's still there, and it'll continue to be there.
So Anna and Saba, each of you have 2 sentences each, and you as well.
I was hesitating when you were saying an expansion of IHL. I think it's actually a little bit the opposite. Other fields are coming in, human rights, maybe international environmental law. So is that an expansion or is it the opposite? And isn't it more a question about international law in general and not specific fields of international law?
Yeah, just continuing with the expansion or even kind of creating opportunity. What I'm following in this conflict, and this is not like a very specific for this conflict, but as Professor Lubel also mentioned, the urban warfare is quite challenging. And in this conflict as well, most of the part of the war, the conflict is fought in cities. So what I'm seeing is that the at least Ukrainian officials made it very clear that they will compensate to the damage of the property of the civilians, which is not necessarily in the IHL, because in urban warfare, you inevitably have this collateral damage, which might come as a result of lawful attack as well. And this comes from probably the compensation from human rights part, like property rights, because in IHL we have only compensation for illegitimate or illegal attacks. So that's something interesting which should be observed.
And Natalia wanted, and she gets the last word.
Firstly, I would like to say thank you for all speakers and for all organization as Ukrainian. And secondly, I would say that IHL is about values, because Ukrainian now have a big request to know about IHL. How IHL protects Ukrainian civilians, firstly. For a small example, in this summer, we teach near 2,000 school teachers on IHL, and a lot of school teachers were from occupied territory. And they request how IHL protect, about responsibility. It's main question for all Ukrainians. Responsibility for individual, responsibility for war crimes, and another issue, responsibility as a state for Russian Federation. That's why it's about value and about how IHL can be actively implemented in war in Ukraine and in other cities. Thank you so much.
So thank you. And thank you, everybody. Thank you to the speakers. Thank you to the audience for sticking so long. And as they say in the airlines, thank you for choosing to come to the Minerva Center. And we hope you enjoyed the journey we've had.